What if you were told that your child must reunite with the very person who hurt them, and you had no choice? This isn't fiction. It's happening in courtrooms across the country, and it's labeled under reunification therapy. Reunification counseling sounds pretty therapeutic, but when abuse has happened, it can be a courtroom order that puts a child right back in the same danger. And the person standing between that child and potential harm? The reunification counselor. That's why the standard for reunification counselors shouldn't just be professional guidelines, they're a lifeline. Hello and welcome back to Black Sheep Diaries, where the black sheep finally get the mic. Now let's be clear, I don't agree with reunification, especially when prior abuse has been documented. That is a dangerous path. But the reality is that fit parents don't have the luxury of always saying no to it. That's because it has been court ordered. Courts can and do order reunification even when it's not safe. And when that happens, the counselor's responsibility becomes even more critical because that child's safety depends on it. So that counselor had better be beyond reproach, ethical to the core, razor sharp, and uncompromising. Because if they fail, if they ignore the history, the reports, the abuse, the consequences land solely on the child when the therapist can go home for the day and forget about it. And make no mistake, that is not just a mistake. That is betrayal, and unethical doesn't even begin to describe the therapist who ignores history. So if you are a parent and you've had no choice in the matter of reunification, let's break down what ethical, responsible, reunification counselors should actually look like. Side note, I am not an attorney and in no way am promoting legal advice. I'm just a parent who has made observations and has done a little digging, which anybody can do. And don't worry, at the end of this video, we will tell you how to get your hands on some very pointed questions that you can ask these reunification counselors. According to Candor Recovery and Consulting, they put it very plainly. The first step in any reunification intervention when abuse has been identified is for the counselor to conduct a comprehensive background review. The goal? To verify that the parent is truly ready and safe to be in contact with the child. That means reviewing everything: prior therapy, prior evaluations, court filings, child protection records, criminal history, all of it. In my opinion, their license should depend on the extensive review before beginning any sessions because this is no joke. Nothing is optional. If they say it's optional, let your red flags wave high and be sure to keep stringent notes. Because when a child's safety is at stake, your child, cutting corners isn't just careless, it's dangerous. This should all go without saying. The child's safety should always come first. But that might be a little too much common sense for some to apply. Because a competent counselor will always prioritize the child's safety, trauma history, and the child's voice above all else. The child should never be forced into sessions that traumatize them. But then again, that's a lot of common sense that we're applying here. They also need to work as part of a team, communicating with the court, visitation supervisors, child welfare agencies, other therapists, guardian ad litems, and so on. This ensures that the child's needs are being met at every single angle. Reunification counselors don't have the option of going rogue in their approach, and every step must be documented, progress needs to be tracked, goals are measurable, the court needs to see that the therapy is working and that it's safe. These should be the bare minimum requirements. The child's best interest must always come first, always, not the court's convenience, the child. Always. This should go without saying. Any counselor who loses sight of this isn't just failing at their job, they're failing the most vulnerable person in the room. But all too often, these standards aren't even met. The abusive parent goes into therapy without showing any real change. The child is forced into joint sessions, sometimes without the safe parent even present. The safe parent is oftentimes sidelined or even penalized. The counselor lacks training in trauma or domestic violence. Therapy goals are vague, progress isn't measured, and the counselor oversteps their role in custody decisions. The child's fear or their resistance to the counseling is ignored. There's no oversight, no one checking in with the therapy to see if it's causing harm. There's no real accountability. So here are just a few points of what a skilled counselor should look like in the case of abuse. They should conduct a risk assessment before any joint session, if there should be a joint session at all. Review the abusive parent's history, prior abuse, protective orders, substance issues, previous therapy, and so on. Track progress, monitor new risk, and report back to the court. Be trained in trauma, abuse, domestic violence, and family systems. Pause or modify therapy if safety concerns or new disclosures arise. But what happens when they don't do any of this? Some refuse to review prior GAL reports at all. Some ignore previous therapy records. Some won't speak to earlier counselors, read court transcripts, or in-camera hearings, all of which recommended no contact. That's more than just unprofessional. It's unsafe and it's unethical. Ethically and legally, therapists are expected to review these extensively, not brush them aside as if they were optional. If you are a parent who was forced into reunification counseling sessions by a court order, you still have the right of freedom of speech when asking questions upon your very first visit. Skip asking the counselor questions like, "Do you have training in?" and fill in the blank. Instead, ask them, "What kind of training do you have regarding?" fill in the blank. Make them show you. Turn it into an interview. Make them prove they are a right fit for the job. Then take careful notes and do your homework on their answers. They shouldn't get a free pass just because they have a few letters after their name. If they can't answer your questions, or it's obvious they're not prioritizing your child's best interest, bring this information to your attorney. If you're representing yourself, consider taking these next steps. Raise the issue in court regarding your thorough note-taking and research. Ask the therapist to document that they have reviewed all records, or request a new counselor. Ask the court to modify the therapy order to explicitly require record review and set timelines before the therapy even begins. File a complaint with the therapist licensing board. Document everything: your communication, their refusals, prior GAL or therapy reports. Next, consider hiring an expert, like a trauma therapist or a child abuse psychologist, to evaluate the therapy and provide that to the court report. Ask the court to halt any joint sessions until safety and due diligence are assured. Obviously, the court can decide whatever they want, but at least you now have a paper trail, which down the road could be golden. Yes, this takes so much work on the part of the parent, and it's time, effort, and stress that you will never be paid for. Just know that up front. This becomes your second full-time job, unfortunately, because here's the truth. When abuse is present, the due diligence isn't optional. It's life-saving. A child's safety should never be negotiable, and no parent or therapist has the right to override that. If you would like a PDF version of pointed questions that you can take into your reunification session, email us below and we will be happy to send you a free copy. If you faced forced reunification and want to share your story, know that you're not alone in this fight for your children. Reach out using the information below, because together we can shine a light on what's been hidden in the dark for far too long.